Good morning everyone, my name is Michelle. I hope you're doing well. Welcome to another video. It's Friday morning and I am giving you a Friday brain teaser. This is a really difficult one, so get your thinking caps on. It's about child offenders and what the criminal justice system should do with child offenders. Why am I doing this video? Because this week, in a 2.5 day hearing, started Monday, finished around Wednesday lunchtime, was discussing whether the then 14-year-old killer of 10-year-old Lily Peters should face trial as an adult or whether he should be tried as a juvenile. And the issue isn't the court per se. Really, it boils down to if someone is tried as a juvenile, then their treatment, their sentence is often much lighter than it would be if they were tried, convicted and sentenced in an adult court. So, do you remember the Lily Peters case? I mean, it's just a heartbreaking case. It really is. This is from last year. It's Chippewa County, Wisconsin. Lily Peters was murdered by her cousin. Now, although he's not named in court papers, he was named at the time in the media. His picture was out there in the media before the court ruled that they weren't going to use his name. However, his own attorney just consistently used his name. His name's Carson. I'm going to use his first name. CTPB is how he's referred to in court documents, but he's called Carson. And he's Lily Peters' cousin. He was 14 at the time of the murder. He's now 15. Since the murder, he's resided in a juvenile facility and he's doing okay. He's doing school. While COVID was going on and there was lots of restrictions in place, he was pretty isolated because he has to have a room to himself because of the nature of his offence. And when doing schoolwork, each child was on a desk on their own. But now that COVID restrictions are lifted, then he's able to socialise a little bit more with his peers. Not that he really wants to, though. And the crux of the matter, the thing that this really boils down to, is the fact that Carson has been diagnosed with autism. And this is the argumentation that his defence are using. His mental capacity does not match his chronological age. Let's just do a quick reminder of this case. Lily and Carson went out for a walk. Lily was riding her bike. He was riding his hoverboard. And this was April 24th, 2022. He claimed to police that he intentionally led Lily away from a trail to explore the surrounding woods. And once off the trail and in the wooded area, he told investigators that he punched her, hit her with a heavy stick, and strangled her until she died. And then he essayed her body after she died. So a grotesque, terrible offence for anybody to commit against a 10-year-old defenceless little girl. But this is what her own cousin Carson did. He's charged with first-degree intentional homicide, essay causing great bodily harm, and essay of a child under 13. In Wisconsin, and I think this is really important, anyone who is at least 10 years old and accused of first or second-degree homicide is considered an adult in the court system. And I find the entire hearing bizarre, honestly, because if that's the law in Wisconsin, why is there even an argument about this? Well, his defence are using the autism diagnosis, saying that his mental age is lower than his chronological age, which was 14 at the time of the offence. But is that autism defence, shall we say, really defendable? I would argue not, for a number of reasons that I was mulling over as the defence witnesses were speaking at the hearing. And it's up to the judge to decide, and the judge has got a very difficult decision to make, and it's going to be months before the judge actually rules on that decision. Look, he's a busy bee. He really is a busy bee. He's got trials back to back. So it's going to be January, I think, of 2024 before the ruling is made. But the defence witnesses, at face value, in my opinion, were strong. But there was a bunch of logical fallacies that they were just bringing in to the testimony, in my opinion. For example, they said that because Carson was autistic, he was socially isolated, he comes from a troubled family, which he does, which he absolutely does. His father is a pedo. He wasn't taught how to deal with his emotions. And obviously at puberty, you've got the influx of new feelings, a flood of hormones. Carson had it rough. He didn't have an ideal family, and he wasn't diagnosed with autism, so he wasn't getting treatment. And I get all that, right? I do. I have sympathy with him in that regard. But that's where my sympathy ends, because Carson knows right from wrong. Carson knew what he was doing. He planned what he did. He planned to take Lily off that trail to essay her. He knew what he'd done was wrong after the fact, because he attempted to conceal her body, allegedly even went back later to hide her body better when he knew that people were looking for her. Unless you want to claim that autism made him insane, which I don't think anybody could claim successfully, then he has to stand and face these charges. But should he stand in adult court or juvenile court? I don't think an autism diagnosis is enough to basically waiver Wisconsin law and say because he's got autism, he should be tried in a juvenile court. Much of their testimony was about the treatment that he'd received post-conviction, and the facility that he's in has the capacity to house him as a young adult until he's 25, and he'd get much better treatment in terms of, one-to-one therapies and so forth than he would in the adult system, because normally he would go to a juvenile centre until he was 18 and then he would transfer to the adult prison system. But how Carson is treated post-conviction, I don't think should preclude him from being tried in an adult court and receiving an adult sentence, because the crime was so heinous. He does know right from wrong. His autism spectrum diagnosis is that of moderate autism. He isn't so severely disadvantaged that he's non-verbal and he just can't associate at all with the world and he's out of the bounds of reality. He's not that bad. I think if Carson is allowed to stand trial as a juvenile and basically waiver Wisconsin law just because he has autism, I think that sets a dangerous precedent. Because what if you were 18, right, so legally an adult, and you had autism and you committed a serious crime, a homicide? You wouldn't be tried as a juvenile, would you? Because your mental age was younger than 18. You wouldn't, would you? You wouldn't go through the juvenile system, would you? So why should Carson, when Wisconsin law states that anyone who is at least 10 years old and accused of first or second degree homicide should be considered an adult in the court system? Now, Carson is not alone in being treated as an adult. A quick cursory glance of Google with the search term, how many children are tried as adults? And it's a very contentious subject. According to the National Juvenile Justice Network, an estimated 250,000 juveniles are tried, sentenced, or incarcerated as adults every year across the United States. But it's a very controversial subject. There's many arguments being made that regardless of the crime, children should never, ever be tried as adults. There's a couple of examples that I want to draw your attention to. The first is one that you will know very well if you're in the UK, and that is the murder of 2-year-old Jamie Bulger from Merseyside. And this happened in the Strand Shopping Centre on February 12, 1993, when she briefly let go of her son's hand while she was paying for some items. CCTV footage showed that little James was being led away by two boys. They took him 2 miles across Liverpool. They tortured him and murdered him. They were actually seen by 38 people during their walk across the city. Jamie was crying, but they claimed that he was their younger brother or that he was lost. They told different people different things, and that they were taking him home or taking him to the police station. And the killers, both aged 10 at the time, John Venables and Robert Thompson, were tried as adults. The age of criminal responsibility in the UK is 10. The judge has a discretion if a crime is so heinous, so serious, that a 10-year-old can be tried as an adult. And Thompson and Venables were tried as adults. It was controversial at the time, and it has remained controversial. They stand as the youngest ever people to be tried for homicide in the UK. Since that time, the age of criminal responsibility, being 10, has been debated. Some European countries it's 14, some it's 12. And there's been this long-standing debate that 10 is too young to be criminally responsible. Is it though? At what age do you know right from wrong? That's what it boils down to. Do you know right from wrong? Do you know it's wrong to abduct a 2-year-old, walk him 2 miles across Merseyside, and then murder him? Do you know it's wrong? Yes. A 10-year-old would know that was wrong. They might not understand the gravity of the situation legally. They might not understand that they're going to face a trial for this, but they understand it's wrong. And in my opinion, that's what this boils down to. However, there were legal challenges to this decision of trying and convicting Thompson and Venables in an adult court. In 1999, the European Court of Human Rights ruled that the pair did not receive a fair trial and were awarded costs and expenses of £29,000 for Venables and £15,000 for Thompson. Lawyers for the pair argued that the adult court venue and the publicity made it impossible for the schoolboys to be given a fair trial. So that's John Venables at the time, that's Robert Thompson at the time. And then it gets heartbreaking. The boys were ordered to be detained at Her Majesty's pleasure, meaning indefinitely. However, in 2001, a 6-month review by the parole board found that they were no longer a threat to public safety and were released on life licence after serving just 8 years. So they were 10 at the time of the offence. They served 8 years. They were 18 when they were released. They did no time in the adult prison system, even though they were charged and convicted in adult court. They were deemed no longer dangerous. Both were banned from ever going back to Liverpool. They were given new identities at a reported cost of £1.5 million. However, in March 2010, Venables was recalled back to prison for downloading and distributing child abuse images. He was jailed for 2 years before being granted parole, again in July 2013. But then he was arrested again and recalled to jail on suspicion of the possession of child abuse images. The Crown Prosecution Service released a statement confirming Venables had been charged. He was sentenced to 3 years and 4 months in prison after pleading guilty to having indecent images of children in his possession for a second time. He was caught with 1,170 indecent photos of children on his laptop. He had 392 Category A, 148 Category B and 630 Category C pictures. He also pled guilty of having a pedo manual. What? Now, Thompson, as far as has been released into the public domain, has not reoffended. So Thompson and Venables have a reoffending rate of 50%. Now, in Carson's case, his assessments, his evaluations, psychologists have said that he's low risk. He's not violent. But he was low risk the day before his offence. He was low risk the day of his offence until he actually committed the offence. And however much training he receives to learn to understand appropriate behaviour, will that really stop him when he's emotionally charged, when he's highly aroused? Hot cognition, as is called in psychology. You can train somebody to your heart's content till the cows come home, to the moon and back, when you're sat in a classroom discussing appropriate behaviour. But when it comes down to it, if you have that type of mindset, will it really stop you in the future? In my opinion, the gravity of the offence that Carson committed, he's always going to be a risk. Always going to be a risk to reoffend, and reoffend seriously. However, it's not the first time that autism has been in the spotlight in relation to how individuals should be treated in the criminal justice system. Let me give you the example of Gary McKinnon. Now, this is a very different type of case. Gary McKinnon was a hacker. He was branded an evil hacker who could end up in Guantanamo Bay. Now, Gary was an adult when all of this was going on. And he says in an interview with Medium.com, "I lost my girlfriend of 14 years, my flat, and my career in IT." The US accusing the self-described bumbling computer nerd from London of committing the biggest military computer hack of all time. Since his arrest in 2002, Gary had been battling extradition to the US. Spoiler alert, in 2010, the US finally backed down and his extradition warrant was withdrawn. So he wasn't extradited to the US eventually, but this was a 10-year battle between US courts and UK courts. You know, the fear that they were going to send him to Guantanamo Bay and he never be seen again. What did he do that was so bad? Well, he hacked into dozens of computers at NASA, the US Army, the Navy, the Air Force, the Department of Defense, and caused damage of around $700,000. In one instance, he's alleged to have deleted files at the United States Weapons Station shortly after the 9/11 attack, rendering the base's entire network of more than 300 machines inoperable. While Gary modestly admits he got access to secret systems, he denied causing damage. The US claimed in his indictment that his hacking was with malicious intent, and he said no. He was just interested in finding out whether he could do this. He was obsessed with science fiction. He was convinced that the US was suppressing alien technology and evidence of UFOs. Well, was he right? Yeah, he probably was. Knowing what we know now, he probably was. He just wanted to have a snoop around. He was autistic. This became his special interest. He just wanted to see if he could do it. And interestingly, he claimed that alien technology that's being suppressed would grant everybody in the world access to free energy. Is that why they wanted to shut him down? Interesting. But eventually, after a 10-year battle, he wasn't extradited. But although computer nerdery, an autistic obsession with hacking into systems and finding out about UFOs and stuff were his special interest, it's no way the same, is it? It's committing murder, an essay of a 10-year-old girl. That really is dangerous. And I believe Carson will continue to be dangerous. And therefore, in my opinion, he knows right from wrong. He should be tried appropriately. But let's see what the judge decides. Let me know your thoughts in the comments below, and I'll see you in the next video. Bye, guys.